that are quite pertinent. They say there was no way of ascertaining the date of the server log, and that was the opening comment. At page 22, comment 8 by Victor, agents wanted to know when Form 34C was uploaded. This was established to be 16th August 2022. How could have it been created on 31st August, but you are able to go back in history to 16th August to determine when Form 34C was uploaded? It's ridiculous on the face of it. My lords, my ladies, I'll take you to George again, page 23. The agent requested to see the whole architecture. The whole, not only RTS, not only KIMS, the entire IBC infrastructure, including everything retained in that server. IBC.
If it may please you, the Honorable the Chief Justice, the Deputy Chief Justice, and other distinguished members of the Supreme Court. My name is Emmanuel Wetangula. I'll be presenting our observations on behalf of IBC with regard to the scrutiny and the recount that took place on the 31st and yesterday, my Lord. First and foremost, I would like to thank members of the judiciary who took part in this exercise. It's the most tedious and laborious jobs, and not the most, and most people actually opted to run away. And even in the submissions before, which I'm about to make before the court today, it will be quite notable that none of my colleagues have addressed the pertinent issue. All the results in the boxes matched the results that have been declared by IBC and the results that were used to declare the president under Article 138.10. My Lord, I'll simply give one example. The application for scrutiny was given by the petitioners, and they identified the stations that they wanted. If this was to be a sample of the entire election, the report bears out the fact that out of the 45 polling stations that were counted, there was no variance of results in the 40 stations, 40 of the polling stations. The report clearly shows that there is no variance of the results with that which was contained in Form 34A. But most importantly, my lady and my lords, there were slight errors which will arise, and it always arises in every election. It's typical to human error. And even to point out this fact, my Lord, I was reading the report that was prepared by the Honorable Deputy Registrar. It also has a slight error. And that error was corrected today when we were sent an addendum correcting a mistake that had been done. Number two, my lady and my lords, at page 31, you will note that there's a slight typographical error regarding the date of the election. It's indicated as 8th August 2017. A normal error that any human being will make. But if it were the petitioners, I'm sure they will pray that the entire report be disregarded. But my Lord, the most important thing is the environment under which elections take place is a very tense situation. And many a times, slight mistakes will occur. For instance, the sealing of documents, the misplacement of one or two things. The only complaint I've had my learned colleagues, Mr. Awele complain about, Ms. Mboshe, and Mr. Willis Otieno. It's about material not being placed in envelopes. But of utmost importance is having been present with every ballot that was counted, it tallies with what was given to each of the candidates. But most importantly, the allegation the petitioners have made and have been running around with is that election results were being taken from one candidate and being added to another. That fact was not proven. This is their case. And if at all there was any variance in the results, I believe Mr. Willis Otieno will have sung for us a new song today, but he didn't. And that confirms that actually the results are believable. And my lords, from the boxes that the court has sampled, there's absolutely no variance. Then we wonder what the complaint is. The slight variances that, or slight mistakes that were noted, which I will just highlight one of them, that one of the parties picked up on. This is number 38 on the list of the polling stations, Kiheo Primary School. One of my my colleagues for the petitioners made reference to it. Despite the absence of the counterfoils, but each of the ballots present matched with the result that was declared for each of the candidates. I wonder how accurate an election can get if this is not it. But mistakes will always happen. And even in the report that is before us, we have noted that actually mistakes actually do happen, and they happen all the time. There was something else that the parties were supposed to deliver, which was Forms 34A. My Lord, a sufficient volume was delivered to the court. I'll just confirm how many there were. There are 32 volumes of Form 32As which have been availed to the court. My Lord, there's also the error form, 3 volumes which have been availed to the court for scrutiny, signed by the chair. These are the errors that were noted during the verification and tallying. And lastly, my lady and my lords, before the time runs out, Book 2 of Form 34A, some of it was found in the ballot boxes during the scrutiny, but some of the boxes did not contain, and it's borne out in the report. But the purpose of printing this booklet is actually known to all the players. My lady, my time has run out. I'll just request for 2 minutes to finalize my points, and I'll be done. Thank you. My lady, with regard to Form 34A, Book 2, the purpose why an extra copy was printed, and it's known to the petitioners, but they will not tell this honorable court, was that at any time sufficient copies of the forms will be available to the agents, candidates, and the media. This is to ensure that the results that were being declared at the polling stations being final were transparent and known to everybody. But a contest arose, and a decision was made by the chairman of IEBC that this material was to be sealed and placed in the ballot boxes. As it will happen, in some of the boxes, and the report will bear it out, some of the forms are not there. And even the report will bear it out that some of the presiding officers made mistakes in Book 1. They cancelled it and utilized Book 2, but still the result did not change. What is important and material is, from the scrutiny that was undertaken until very early hours of yesterday morning, the result matches what is contained in Form 34A. And my lords, those Form 34As have been availed to the court pursuant to the rules of the Supreme Court, and they are the forms that were used to declare the results of the election upon the completion of the exercise. Similarly, these are the same forms that were transmitted through the results transmission system, and they match each and every other form that was given. Lastly, and very lastly, there was in one station in Kakamega where the Form 32As were not availed, and affidavits to that effect have been given, and the reason is that because of an outbreak of violence, the affidavits will bear it out. With those few remarks, my lady and my lords, Professor Mugai is asking for a donation of the time, but it has run out. Thank you very much.
Well, Lady, without appearing to interrupt the court's proceedings, with that kind permission, my learned friend has made reference to an affidavit that was given. We've never been supplied with that affidavit. We don't even know about it. And I don't think it is proper for evidence of such a nature to be brought to court at this critical point. And I wish the court should ignore it.
I don't think we are aware of it, because we closed the filing of proceedings in this matter.
Very kindly request you to allow me to place on record that we reserve our right to object to that document filed by my learned friends. First, because it was filed without leave. Secondly, because no other party has had the opportunity to do the same. Thirdly, because from what we hear now, it may very well contain falsified documents.
Yes. Have we had submissions from the 9 respondents, but now in the... Yes. Yes.
Madam Chief Justice will be making a formal application for the document tendered by Learned Counsel Mr. Mulgo to be expunged from the record. But first things first, we shall respond pursuant to the order issued by the court. We were to orally respond,
Yes.
not to use that opportunity for other filings. On our part, 2 of my colleagues will make the oral submissions. Please, we hadn't started making the submissions.
If it pleases the court, my name is Omwanza Ombati. I'm going to present the first part of the comments about the scrutiny report. And the second part will be presented by my learned friend, Senator Hilary Sigei. My lords, it's important to first appreciate that the purpose of scrutiny action was conducted. And that's what you said in 2013, Raila. And secondly, also it's important to note that part of the process of scrutiny is to audit the election and make sure that the numbers are backed up by the paper trail. In the request for scrutiny that was done by the petitioners, my Lord, Chief Justice and members of the Supreme Court, the request was targeted. You'll find that particularly in petition number 5, and also the affidavit of Arnold Oginga, paras 81 to 91. That is where the scrutiny was ordered, and when you retire to consider this matter, my lords, I request that you restrict them to their case. Now, in terms of the orders that was given by this court, you'd find that there are 7 orders. I'll deal with order number 1 to 4. The first one was with respect to an order that IBC should provide the applicants with copies of the technology system and security policy. This was complied with, except that the applicants also wanted the names, specific names of the system administrators. My Lord, this will not be possible because then you would expose system administrators to danger. The second order is with respect to a supervision of the servers, to have access to the servers of the National Tallying Center, to demonstrate how Form 34C was dealt with. The forensic image of the 34C was granted, and all parties were also given time to interact with this server the whole day. Now, the third and more important, part of that order also was to see whether there was any deletion of any Form 34A at the server. You'll find that at page 21 of the registrar's report, there was no deletion. There is not a single deletion of a Form 34A from the server. And my Lord, Justice Lenola asked a question on how was it that JPEGs were converted from JPEG to a PDF. My Lord, that answer is found at the registrar's report at page 12, and it's important that we read this. It's a short page because a lot of issues have been raised about this. You'll see whereby it says that the Form 34A, you'll find this at page 12 of the registrar's report, that the Form 34A would be scanned by the KIMS kit into a PDF, which was then transmitted into the storage server. At the storage server, the form is processed by an application to check for compliance, to certify that the security features have been complied with, and the PDF has all the features that are supposed to be there. That goes also to page 13. This is important because, my lord, there was a theory of the middleman that was being propagated by one of the petitioners, and in this scrutiny we could not find any middleman. In fact, there was a direct link from where the results were transmitted. So the transmission was from the KIMS kit. It would go to the National Tallying Center. One form would go to the National Tallying Center. The second form would go to the constituency Tallying Center. And the third form would go to the portal. And in this path, results path, there was no middleman. That was the smoking gun that was used by the petitioner, and, my lord, unfortunately, there was no smoke, and there was nothing that would find, that was found in that. It's important, my lord, to demonstrate to this court that in the scrutiny, there was first compliance by IEBC about, in terms of the orders of this court, order 1 to 7, as far as was practicable. And number 2 is that in the case theory that was presented to this court completely collapsed. We are all aware, and we saw it, that the petitioner brought a case that was packed in a truckload. However, when that was subjected to scrutiny, it collapsed like a house of cards. So, my lord, the scrutiny has demonstrated that this election was conducted in substantial compliance with the law. If there are variations, they are minor and they do not materially affect the result. And we submit that this court should validate the win of the first and second respondent in terms of Article 140 of the Constitution. I would conclude and say that from what we've heard, my lord, it's important probably to, for those of us who didn't go to the schools that my friend Ayatollah went to, if you read the book of Macbeth, the play of Macbeth, the second play, you'd see that there's a debate. There's a debate about the devil and conscience. I think in one of the last acts, about a servant who's known as Lancelot. And this servant has this big debate on what is it that, he has the devil that is pushing on him and also his conscience. And he concludes that he would rather go, in fact, I quoted this because it's very interesting. He says that my conscience is hanging by my neck, the neck of my heart, and in my conscience is a hard conscience. However, the devil gives me a more friendly counsel, but I choose to run from that friendly counsel. My lord, with those few remarks, I will request that my learned friend, Senator Hilary Sigei, can continue.
The Honorable Chief Justice, the Honorable Deputy Chief Justice, and the judges of the Supreme Court. My name is Hilary Sigei. My remit in submitting on the basis of the report is limited to the numbers. And my lords, I would dare say, fiction is best told in abstract. My learned colleagues for the petition have taken you through what they called a product of scrutiny. They have intentionally left out what is also equally important besides the process, and that is the numbers. I associate myself largely with the submissions by my learned friend, Mr. Wetangula, particularly with regards to the numbers and the 45 polling stations, which was a subject of inquiry in the orders for scrutiny. Given, my lords, that the election process in Kenya is a process that we are conducting 6 elections in one day, it is natural that errors, especially in counting, tabulation, are bound to occur. But far from that, when the 45 polling stations that this Honorable Court directed that a conduct of scrutiny be done, the recount confirmed that there was correct vote count in 45 polling stations. It also confirmed that all the data that was entered, including, for example, the rejected votes, reflected that which was in the ballot and that which was in the image. It also confirmed that the Form 34As were not altered as it has been submitted before you. I therefore do submit that there are no irregularities in terms of the votes cast against each of the candidates in this particular petition. There was also no transposition the way they had placed that votes from candidate A was taken away and given to candidate B. That product of scrutiny has confirmed that. To be very specific, in Mombasa County,